Hello, I'd like to talk to you today about shareholders and unit holders agreements. And this is part of a series on business succession planning. Now, shareholders and unit holders agreements, as the title suggests, are contracts between shareholders, if it's a company, and unit holders, if it's a unit trust. And they regulate the conduct between the shareholders and the unit holders in that capacity. Now, why I say that is because shareholders agreements, for example, do not regulate the conduct of directors of a company. That's a separate thing. They regulate only the shareholders' conduct as shareholders. Similarly, unit holders agreements regulate the conduct of unit holders as unit holders. They don't seek to impose upon the fiduciary duty of the trustee of the trust. Now, there's some overlap between a company constitution and a shareholders agreement, and between a trust deed and a unit holders agreement. It's not the case that those documents must be mutually exclusive. They can deal with similar sorts of things. Now, these agreements are often used to regulate such things as voting, to break up deadlocks, and to deal with such things as buyouts and drag-alongs. By voting, what do I mean? Well, of course, in general meetings, company shareholders and unit holders get to vote on certain resolutions that are put forward. Shareholders and unit holders agreements are nothing more than an agreement between shareholders to vote a certain way in a certain interest. And that's quite an appropriate thing to do. Breaking deadlocks. Well, that might seem self-evident. You could have a situation where a company shareholding, it might be a 50-50 shareholding, is deadlocked, and the agreement can be used to put in place a mechanism to break that deadlock, whether by some form of external arbitration or something of that nature. Buyouts and drag-alongs. You might find a situation where a particular party wishes to sell out of a trust or a company, and the procedure for dealing with that is enshrined in either the shareholders agreement or the unit holders agreement. So, for example, if sufficient shareholders wish to sell their shares, a drag-along clause basically makes the remaining shareholders sell their shares to the new purchaser on a certain formula. A buyout, on the other hand, is a means by which one party wishes to acquire the shares of another party, and a buyout clause puts in place a mechanism for dealing with that, dealing with such matters as valuations and the triggers and the percentage that you need to commence a buyout procedure. Now, the question is, do you need a shareholders agreement or a unit holders agreement? As I've mentioned, my impression is that more people need them than in fact have them. And what I would say in relation to this is, consider the future. Consider what will happen when you want to leave the business, when you want to sell the business, how you would deal with your fellow shareholders and unit holders in that circumstance. You might find that putting an agreement of this type in place early on smoothens what can be quite a rough procedure somewhat down the track.